Okay, well, welcome and thank you everybody for joining us today. My name is Darren Richardson. I'm COO with Morris Hall. On behalf of Morris Hall, we would like to thank Sun Health Foundation for the privilege to present to you today. Before we get started, I have just a few housekeeping announcements. Your microphone and camera will be disabled throughout the webinar. However, if you have any questions for our presenter, you are welcome to submit them in the Q&A box located in the toolbar on the bottom of your screen. We will respond to questions at the end of the presentation, so we appreciate your patience. We ask that you silence or turn off your cell phone during the presentation so that you may participate free of distraction. And if for any reason you are disconnected from the meeting, you can rejoin using the same link you used to join, or you can re-register by clicking on the upcoming events link at sunhealthfoundation.org. Now, just a brief overview about Morris Hall. Morris Hall is comprised of 10 attorneys and 17 team members with 13 offices throughout Arizona and New Mexico. Our firm practices estate planning exclusively and is a charter member of the American Academy of Estate Planning Attorneys, a premier national organization committed to excellence in estate planning by providing its exclusive membership with up-to-date research, educational materials, and other vital practice management support. And we are celebrating our 50th anniversary of serving clients throughout the Southwest, and we look forward to many more years to come. Video clips will be shared at certain points of the presentation, which may be harder to hear, so please make sure that you adjust your volume accordingly. And now I will turn the time over to Gina Orr, Chief Philanthropy Officer with Sun Health Foundation, and she will introduce our topic and our presenter, Dave Eastman.
Welcome everyone. We're so glad to have you with us for this webinar. Thank you for taking the time. My name is Gina Orr, Chief Philanthropy Officer for Sun Health Foundation. Our story of community support for superior healthcare and wellness services in the West Valley spans more than 50 years. Today, the Foundation story continues as a philanthropic partner for Banner Boswell and Banner Deli Web Medical Centers. Preserving your story includes planning for the inevitable and protecting your family so new chapters can be written. How will you be remembered? To help you answer this important question and more, our guest presenter is Dave Eastman, estate planning attorney and partner with Morris Hall. Dave also serves on Sun Health Foundation's Board of Trustees. With his years of experience serving thousands of clients, he offers great perspective on what you need to know. Following his talk, Dave will answer your questions and will close with some inspiration from Pastor Lowell Nelson, who also serves on the Foundation's Board of Trustees. Now it gives me great pleasure to introduce Dave. Dave?
Good morning, everybody. Thanks for joining us. It's wonderful to be with you this morning. Hopefully everybody's safe and doing well in this crazy, chaotic world that we're now living in. And I'd just like to say thanks to Sun Health Foundation and Gina and her team for putting this presentation together and for allowing us to speak to everybody today on a topic that we feel very passionately about. And hopefully it's of some use to you and you can share it with your family members and friends, and you can gain something from our time we're going to be spending together today. Just a quick overview of what to expect from today's presentation. Hopefully we're going to make it through this presentation in about an hour. I'm going to be feeding you through a fire hose today. I'm going to give you a ton of information in a very short amount of time. Certainly my goal is not to make you estate planning attorneys. I wouldn't put anybody through that or make you go through that. But my goal is to give you little nuggets that you can hopefully use to plan for the inevitable. So we're going to leave about 15 to 20 minutes at the end of the presentation for Q&A. I'm sure a lot of you have questions. We have already received some questions ahead of time, so we're going to make sure we leave some time for questions at the end of the presentation. And we might not be able to get to all the questions, but we'll do our best to make it through as many of those questions as we possibly can today. So our topic today is how will you be remembered? And we're going to be discussing the mistakes that we often find people make when they plan their affairs. And we're going to be going through those mistakes, how we can avoid those mistakes, steps that we can all take today to make sure that our estates are in order and we're not leaving a mess behind. So hopefully everybody's had their coffee this morning. You're ready to go. Let's talk about two really fun topics, death and taxes. And for the next hour or so, we're going to be talking about those two topics today. One thing just to kind of go over with you here real quick is this evaluation form that is going to pop up at the end of the webinar. So at the end of the webinar today, you're going to see an evaluation form that's going to show up in your browser. It should automatically just show up in your browser. There's really nothing that you have to do. It's embedded in the Zoom meeting, so it should just automatically populate into your browser once the webinar is done. So I'm going to go through the meat of the presentation. We'll leave some time for Q&A at the end, and then we're going to have a short message, like Gina said, from Pastor Lowell Nelson, who will give our concluding remarks. After his message, the webinar will end, and then once the webinar ends, this evaluation form should show up in your browser. Please, please, please take the time to fill out this evaluation form. It helps us out tremendously. It lets us know how we can improve, things you like, things you don't like. Certainly topics that you'd be more interested in learning about, you can put that on the evaluation form. So for upcoming webinars, we can go through those topics and discuss things that are of importance to you. Also on this evaluation form is going to give you the opportunity to schedule a free consultation with myself to do an estate plan review for you. So if you want to have your estate plan reviewed and discuss your estate plan, going over your goals, what you're trying to achieve. If you don't have an estate plan, why you need an estate plan, talk about your personal interests and goals. If you have special needs children or grandchildren, how we have to plan specifically for them. So that gives you the opportunity for that hour and a half of free time of mine to come in and sit down with me and go through those things together. And then at the end, we can kind of map out how we can best plan for your estate. Also on this evaluation form, you're going to have the opportunity to schedule a meeting with Gina and her team at Sun Health Foundation to discuss your philanthropic desires. And if you're charitably inclined, if you want to leave a charitable bequest after you've passed away to benefit your community, Sun Health Foundation, you can sit down with Gina and her team, and she can certainly go through that with you and help you achieve those charitable desires that you may have. So please fill out the evaluation form at the conclusion of our webinar today. So our topic today is, how will you be remembered? And this is what we're going to spend the majority of our time on, is going through this. And really, there's a couple of assumptions I'm going to assume about everybody that's attending our presentation today. Number one is, I'm assuming everybody knows that you're going to die. We're not dealing with any delusional people. We all know that sooner or later, we're all going to pass away. It's going to happen. There's no cure for death. And the second assumption is that most of you, if not all of you, have worked extremely hard for the money that you have and that you've earned. You put a lot of time, a lot of energy, a lot of effort into accumulating the nest egg that you have. And so the question becomes, how do we plan for that? You know, a lot of you sacrificed and put a lot of time into that. You didn't get it from winning the lottery. You didn't get it from a large inheritance that somebody left behind to you. You sacrificed, you put a lot of time into this nest egg that you have. And so we want to talk about how you can be a good steward over that nest egg and make sure that nest egg is going to go to who you want, when you want, how you want, with the least amount of expense and delay and the greatest amount of privacy. And so if those are your goals, if those are your estate planning goals, if you've worked very hard for what you have, you know you're going to die, we're all going to die, how can you best plan to make sure that when death does occur, your affairs are in order and things are going to be passed to those that you love the most as efficiently as possible with the least amount of expense and delay. Certainly, the last chapter in your life story is not going to be your death. There are going to be 2 or 3 more chapters after you die, and those chapters are going to either be filled with joy and happiness and fond memories of how simple you made things and how organized you were, or they will be filled with chaos and heartache and a lot of anger with how you left things. So our goal today is to go through how we can make sure your affairs are in order. So those last chapters are nice, kind chapters written about you, as opposed to your loved ones cursing your name the rest of their life after you've passed away. So let's get started with some of the things that we can make sure that we're doing to make sure our affairs are in order. I'm not sure if you've seen the movie Knives Out. If you haven't, highly recommend you watch that movie. We all have a little bit of more time on our hands with being in quarantine, some of us, or not being able to go out and do all the fun things we used to do with COVID-19. So maybe take the time, rent that, and view it. It's a great movie about estate planning, and we certainly don't want that to happen to anybody that's on this webinar. The chaos and the heartache and the trouble that was left behind after the patriarch passed away in the family. And so here just is a little picture that kind of shows you the chaos that we often see as estate planning attorneys when clients don't organize, they don't plan for death, and they leave a mess behind. Family disputes that are often happening. Decisions such as, should we keep mom or dad on life support? Should we remove her from life support? Burial decisions. Does mom want to be buried? Does mom want to be cremated? If mom wants to be buried, where does mom want to be buried? So, sorry, I just clicked past that. Right? Go back here. So these are things that should be decided ahead of time. These are things that we want to make sure are decided and discussed before they actually happen. What kind of a casket do you want? Do you want to be buried in the most expensive casket? Do you have a prepaid burial plan? Do you not have a prepaid burial plan? If you have a prepaid burial plan, who's the prepaid burial plan with? Have you cut somebody out? Have you decreased a child's share? Have you made gifts to one child during their lifetime, and so their inheritance is going to be less? Have you made loans to certain children that need to be paid off after you pass away? Those are the types of disputes that often arise when death occurs, and they divide families, they break families apart. So we want to make sure that we minimize those disputes as much as we possibly can before death occurs. Court hassles. There should be no reason why anybody on this webinar today goes through something called probate. With the information we're going to share with you today, everybody should know how to avoid probate, the steps that you can take to avoid probate. So very important that you take the necessary steps today to minimize those court costs and attorney's fees, unless of course you want to build inside your estate plan. I want my favorite estate planning attorney to receive 3, 4, 5% of my estate, then certainly leave a mess behind, and the estate planning attorney will thank you and praise your name every day of their life after you're dead. But of course, that's not what we want. You worked hard for your money. You want your money to go where you want it to go, not to the attorneys and court costs and fees and all that. And then finally, taxes. There are certain taxes that we want to make sure we try to minimize and avoid having to pay. Certain taxes we can plan for ahead of time to make sure we mitigate that. So just real quick here, I'm going to go to our next slide. And these are the 8 things to do steps we can take today to make sure that we leave a lasting legacy behind. A legacy that will comprise the final chapters of our life, where loved ones will actually be thankful that we did these things and remember us for how well we planned our affairs before death occurred. So we're going to be spending most of the time on this. I'm actually just getting some text here. And of course, when we have technology, we all have to be a little bit patient as we're using technology. I'm getting some feedback saying that some people can't see my slides. Hopefully that's not the case with everybody, but we certainly want to make sure that you can see the slides. So it looks like some people are saying they see the slides and others aren't. Let's see, let's just make sure we're making sure everybody can see it. Not seeing slides, okay. We see a split screen between you and Gina, who appears frozen. All right, let's see if we can maybe stop sharing this. I'm going to stop sharing for a second and we'll see if we can pop back on. Let's see. Can anybody see this slide now? Maybe you can let me know. Yes, yes. Okay, there we go. I'm getting a bunch of yeses. So this is good news. Can see the slide. Thank you. Okay. Technology, you gotta love it. Sometimes it works great and other times it's a mess. We spent about 3 hours this morning making sure that this was working properly and did a dry run through on this a few times, and it was working great then. And of course, when you go live, something always happens. So we'll keep our fingers crossed that it's working now. Everybody can see the slides, and it's working how it should. If it's not, let us know, and we'll try to make it work. So hopefully everybody can see this slide. Honestly, this is the most important slide that you're going to have anyway, because it's talking about the steps that we can all take to make sure we plan our affairs as best as possible. So we're going to go through each one of these, spend quite a bit of time on this slide. So no, I'm not advancing slides here for probably the next, I don't know, 10, 15 minutes. This is where we're going to spend the meat of our presentation is on this slide. We're going to go through each one of these 8 things that we can all do to make sure our affairs are in order, and then we'll go from there. So number one thing that we often see as estate planning attorneys, I see this almost every single day in my office, is just the lack of organization. So the number one piece of advice I can give all of you that are attending this webinar today is to get organized. Please, I pray, get organized. Do it while you still have mental capacity, while you still know what's going on, and get your affairs in order. It's the best thing you can do for those that you're leaving behind. I did a short video clip to invite some of you to our webinar today about a client whose husband passed away, and she had no clue what any of the assets were, how to get in touch with any of the professional people that her husband and her had worked with, like CPAs, financial advisors, attorneys. She let him do everything. And so when he passed away, she was at a loss. She literally came into the office and said, I have no clue what I'm supposed to do. And so I said, okay, well, your first thing is you got to go home. You got to bring back in all of your information. You got to gather as much information as you possibly can and bring it back into me. And then we can maybe make our way through that. Well, about a week goes by and she comes in with a Depends diaper box. No kidding. It was a Depends diaper box that had been emptied. And she had just shoved all of her paperwork, not organized, not in nice little files, but just paperwork shoved in there, tax returns and everything she could possibly find in the house. She shoved inside this box, and she drops it off on my desk and gives it to me. Don't do that to me. Don't do that to your loved ones. It's the worst thing you could possibly do. So get organized. What does that mean? Well, it means going through your drawers, getting rid of stuff that you don't need anymore. You know, if you have old life insurance policies, get rid of them. You don't need them anymore. If you have old deeds to real estate, get rid of the old deeds. You don't need those anymore. You know, and how often do you pull out the old deed from Cherry Lane and reminisce, oh, I remember when we used to live there. You don't do that. You've sold the property. It's not yours. Get rid of it. You don't need it anymore. All it does is cause confusion for those that you've left behind. Old bank statements for institutions that you no longer have accounts at anymore. Get rid of that stuff. All it does is cause confusion for them. And so keep a nice organized list of everything that you have, everything that they need to do, where to find everything, make it nice and easy. So organization is the number one thing I recommend that you do. Some of us like to hoard and keep lots of stuff. Please don't do that. It's a nightmare to go through, and you know, billing at $4.50 an hour to go through that stuff. That's not the way to plan your affairs after you've gone. We certainly don't want a huge chunk of your estate to be going out to attorney's fees to sort through that just because you weren't organized ahead of time. Number two is make a contact list. Very important you have a contact list that shows all the important people that have to be gotten in touch with after death occurs, such as your CPA. What is their phone number, or who are they? Your financial advisor, your law firm that you're working with to do your estate planning, your funeral home. How do we get in touch with them? So all the important people that need to be gotten in touch with, you want to make a list of all that. In addition, you want to make sure you have a list of your credit cards, your debit cards, your charge cards, a list of all of your assets. I would have a nice list that you update every single year you're doing this. You're updating your list of assets that say, these are all the banks that we have checking accounts at and savings accounts at. These are the account numbers. This is our financial advisor's information. He has these 4 or 5 accounts. Do you have life insurance? If you do, who's the beneficiary of the life insurance? Make a list of that. Do you have annuities? Who are the beneficiaries of the annuities? Make a list of that. IRAs, 401ks, 403bs. Make sure you have lists of all those. Is there a pension that needs to be dealt with now that death has occurred? If so, what's the organization? How do you get in touch with them? What's the phone number? You want to try to make things as easy as possible for your loved ones after you pass away. So once again, they're not cursing your name every day of their life now that you've passed away. Your bills, your debts. So if you have automatic withdrawals coming out of your accounts every single month for certain things, you want to make a list of those so that we can close those down, shut those out, so that they're not the fees aren't coming out every single month. We can stop those. You know, who's your cable bill through? Is it Cox? Is it CenturyLink? Who's your cell phone bill? Is it Verizon? Is it Sprint? Who are your debts with? Who do we have financial obligations to that need to be settled and satisfied? Make sure you have a list of all those things. And that's just part of getting organized. 4th thing is to write a letter to your loved one or loved ones. We often recommend this. Very rare that I ever see it happen, but I will continue to recommend it. I think it does a lot of good. So your loved ones are not, when they come in and see us, you've seen those movies where they do a reading of the will. Well, it's very similar what happens, you know, in the movies. So when death occurs, your loved ones, whether it's your kids, your niece, your nephew, your neighbor, whoever is in charge of your estate, is going to come in with your estate planning documents to an attorney, and they're going to sit down, they're going to go through your estate planning documents and say, okay, this is what needs to happen. This is how we have to get in charge of assets and steps you have to take to do certain things. The last thing your kids are going to remember about you is that binder that your estate planning attorney created for you. They're going to care less, you know, the 500 pages that are in that binder. What they are going to care about is that letter that you've written to them. So these are letters that are personal to them. What are your hopes? What are your wishes? What are your dreams? What are your aspirations for them? If you were philanthropically minded while you were alive and you want them to continue on that legacy after you're gone, put that in a letter saying, I hope that you would take some of this inheritance and benefit your community in these ways. Those are things that they're always going to remember about you. So take the time, write a letter, do something like that. Hopefully they'll always remember you for. Not a place, certainly, to be critical of your children. The last thing they want to hear is, you know, in the 8th grade, you got a C in geometry class, and I can't believe what an idiot you were. Don't put that in writing. They don't want to hear that stuff. Be kind, be gentle to them in that letter, or don't say anything at all. Personal property. The number one thing that we see litigated after death occurs is not the life insurance policy. It's not the house. It's not the car. It's not the checking account. It's the personal property. It's the stuff that has sentimental value to your loved ones. So it's the frying pan you made chicken in every night as your kids grew up. It's the cardinal birds that dad made in his garage, in his wood shop. Those are things that they'll fight over time and time again. So please take the time, make a list of all the personal property, and then decide who's going to get those personal property items. So you can just put on there, I want the grandfather clock that came over from Germany to go to Bob, and I want the diamond rings to go to Susie. So that's a personal property letter, distribution letter that you can actually write. It's not part of your will. It's not part of your trust. It's a separate list that you can make up of personal property items and who those items should be going to when you've passed away. So please take the time to fill that out and make that list. Very important to do that. Number 6, have your estate plan reviewed. We recommend that you have your estate plan reviewed every 3 years. So our clients come in and see us every 3 years. We sit down and we review the estate plan. We go through it. Doesn't mean we have to make changes every 3 years. It just means it's like a dental checkup, right? You go in and see your dentist every 6 months or however often you go in. And sometimes you go to the dentist and they say, you're good, just had to clean some teeth and you're fine. And other times you go in and say, oh, there's a filling, we gotta get this done and this taken care of. And it's the same with estate planning. So estate planning isn't one of those things where you check the box and say, it's done, I don't need to worry about it anymore, I never have to look at it again. Estate planning is something that you're constantly reviewing and making sure it's up to date. It's important to do that because things change. Your lives change, your kids' lives change. Maybe you have new grandkids that you didn't have 10, 15, 20 years ago when you originally set up your estate plan, and now you want to provide for them. Well, your old trust or will doesn't include them, so that needs to be updated. You've acquired new assets. You had different bank accounts 20 years ago than you do today. You used to live in Illinois and now you live in Arizona. So you sold your Illinois home and you have your Arizona home. So does your estate plan include that? Maybe one of your grandchildren is now disabled and is special needs. Your old plan didn't take that into account. Your new plan needs to. So those are things that we want to make sure we're including. Sorry, I'm just checking the chat box to make sure we're not having any more technical issues. I might periodically do this as we're going through just to make sure everybody's still seeing everything. But I don't see anything in the chat box that says we're having problems, so I think we're good. But it's important to make sure that your estate plan is reviewed periodically. Also, there's law changes that occur. You know, unfortunately, I don't control the judges or legislators any more than you do, so laws are going to change, and it's important that you understand how those laws are going to affect your estate plan, and if you need to update your estate plan because of those law changes. So every so often you're going to want to come in, have it looked at, have it reviewed just to make sure everything's still working like you thought it was working. And if an update needs to happen, then we need to clean it up and update the documents. And it's not hard, it can be done. Number 7 is talk to your loved ones about your estate plan. Kind of interesting that this has to be on the list, but I can't tell you the number of times where clients will spend all the time, energy, and effort creating their estate plan and putting the money into this nice big binder with all your legal documents, your trust and wills and powers of attorney, and then they never talk to their loved ones about the plan. They never tell them where to find the binder. They never tell them how to get in touch with the law firm. They never discuss, you know, what's going to happen when the client passes away. You know, who's the trustee of the trust? If they talk to the trustee, does the trustee know that they're going to be the one in charge of administering the trust? If you have a will, have you talked to your executor that you've nominated inside your will? Do they know what their responsibilities are and what they need to do? So those are all things that you certainly want to talk to your loved ones about, making sure they know where to find the estate plan, how to get in touch with the estate planning attorney, and the first 2 or 3 steps that they need to take when death occurs. You have to remember, it's a very emotional time when death occurs. If you've been married for a long time, when your spouse dies, you're in a very emotional state. If you're single or you both die and your kids are the ones administering your estate, it's a very emotional time for them. So they're worrying about the burial costs and you know, how to make sure that your funeral arrangements are all taken care of and your wishes are taken care of in that regard, and bringing people into town and paying for hotels and food. And the last thing they're thinking about is the legal documents and what do I need to do? And so you want to make sure you have the discussion ahead of time. I always talk about the Boy Scout motto, which is be prepared. You know death is going to occur. There's 2 things in life we can be certain of, as Benjamin Franklin once said, death and taxes. If you know those 2 things are going to happen with certainty, they are going to happen, then those are the 2 things in life you should be planning for more than anything else. You should be planning for when death does occur and how do we minimize taxes. So talking to your loved ones is one of those steps you can take to make sure you're planning for death and when it does occur, so that they're ready for that storm when it hits. It's not like a deer in headlights and they're saying, oh, what do I do now? What's the first thing I got to do? What's the first step I got to take? This should have been a discussion you've had with them already, and they're prepared for it. They planned for it. They're ready for it. It shouldn't be a big shock to the system for them. That's the last thing you want. Number 8 is fund your trust. So assuming that some of you on the webinar do have a trust, and we're going to talk about a trust here for a little bit. But if you have a trust in place, the number 1 reason why trusts fail is because you don't fund the assets into your trust. So you you spend all the time and the energy and the effort and the money to create your trust, 20 years ago or however long ago it was. And then time goes by and you forget to put your new assets you acquire into the trust as time goes by. And then you die. Well, your trust is unfunded. You've left assets outside your trust. And when you leave assets outside your trust, if they exceed a certain dollar amount, then we have to go through something called probate, which is what we're trying to avoid by having a trust. So very important that if you have a trust, make sure your trust is funded, make sure you've taken the time to actually put the assets in the trust, stay on top of that, be diligent about making sure that you're constantly keeping those assets inside the trust and keeping the trust funded with those assets. Otherwise, you're negating the whole purpose of having your trust, which is to keep you out of probate when death occurs, which just once again means attorneys' fees, court costs, time, delay, expense that goes with probate, which is not being a good steward over your legacy and what you've worked so hard for. None of us should want to go through that. So keep that in mind. The basics of a trust, I know there was a couple of questions that came in before the webinar presentation that talked about, well, do I need a trust or a will? And that's not really what the presentation today is about, but it is about how will you be remembered. And so I'm going to just spend a couple of minutes talking about a trust and how a trust works and how a trust is different than a will. The main difference between a trust, and the type of trust we're talking about is a revocable living trust, revocable, tomato, tomato. So it just means you can change it, amend it, alter it, revoke it at any time. The main difference between a revocable living trust and a will is a trust is going to keep you out of probate, and a will is going to put us in probate. So the actual Latin definition of probate means to prove up a will. That's what we're doing in probate, which we're proving up the will. We're making sure the will was executed validly in the state that you created the will. Whereas with the trust, we're not going through probate, which means saving on attorney's fees and court costs and time and delay and expense and publicity and all the stuff that goes with court. The trust will take care of that. In addition, if the trust is structured properly, so in addition to keeping us out of probate, there's lots of other things a trust will do that a will won't. A trust can help make sure that the assets are preserved for our loved ones after we pass away. So it can make sure that if we have a special needs child or grandchild and we're trying to make sure that their disability benefits are provided for after we die from the state, they're not cut off from those disability benefits, a trust can be set up for that special needs beneficiary through your trust, through something called a special needs trust. If we have children that are spendthrifts, we can keep assets in trust. If we have children that are married to the slimeball in-law that none of us like, we can keep the assets in trust so that the son-in-law or daughter-in-law that we don't like doesn't have access to that money. We can shield and protect the assets in trust from creditors and divorces and bankruptcies that our children or grandchildren may go through. So there's lots of good things that a trust will do that wills won't do. So when we talk about how will you be remembered, if you're trying to make sure that everything is going to be protected and passed on as efficiently as possible with the most protection we can possibly put around those assets, a trust is by far the best way to go. And it's also the simplest way to administer your affairs after you've passed away, as opposed to a will where we have to go through probate and do all that. So just a quick kind of summary there of the difference between a living trust or a revocable living trust and a will. All right, so important decisions at a very emotional time. Some of you on this webinar have been married for 40, 50, 60, maybe even more years than that. So you just have to remember that when death occurs, it's a very emotional time. You're grieving for the loss of the person that's been by your side for the last 40, 50, 60 years. Your best friend, the person that's always been there. And now that person is gone and they're no longer there. And not only are you grieving their loss, but you have all these decisions that also have to be made. Once again, the best time to prepare for a storm is not when we're in the eye of the hurricane. The best time to prepare for the storm is many, many, many days ahead before that storm even hits. And we know what's going to happen. We have a plan. We're prepared. our affairs are in order. We've talked to the professionals that need to know what's going on. Our spouse knows what's going on. Our kids know what's going on. So that when death does occur and these decisions have to be made, the money decisions, the paperwork, the change of beneficiary forms and tax filings and life insurance forms and rolling retirement plans over or annuities over, and getting date of death valuations and appraisals and contacting the financial institutions, retitling assets, recording death certificates, deed work that needs to be done for real estate. All of these things you've already discussed and you have a plan for. So the first time that this conversation is happening should not be when death occurs. Not for the spouse, if it's a surviving spouse coming in, and it certainly should not be that case for your children or your loved ones, whoever it is that's going to be settling your affairs after you've passed away. These are discussions and conversations that should have been happening a long time ago, so that they're prepared for it. They know what needs to happen with each one of these things and who they have to get in touch with to make sure that each one of these things are taken care of and administered as efficiently as possible without a lot of delay and expense that goes with that. Some of these things on here are time sensitive. Your retirement plans have time sensitive triggers attached to them. So we can't let too much time pass before we deal with those issues. Otherwise we get hit with some penalties on retirement accounts. So we have to be aware of those things. And what are those time frames that things have to be done? Those are conversations you certainly want to have with your loved ones. The other thing to keep in mind is tax filings. Some of the tax filings have time sensitive triggers attached to them. So if we have to do an estate tax return, we want to make sure you understand when the deadline is that has to be filed. There's something called portability that we have to elect if we're trying to port the deceased spouse's unused federal estate tax exemption amount over to the surviving spouse. That's a lot of information there, and I know it's you're sitting and saying, what did he just say? And I don't understand what he just said. But basically, when death occurs, if we want to preserve some of the deceased spouse's unused federal estate tax exemption amount, which is $11.58 million today per person, then we have to file a tax filing when death occurs within a certain amount of time. And so we want to make sure you understand what that time frame is and what has to happen. And you should already have that mapped out, and you should understand that, so that when death occurs, we're not scrambling at the last second trying to get that done, and you're stressed out and you're emotional because death has occurred. Those are things that should have been discussed ahead of time. And certainly family matters. We want to definitely make sure that those family matters we previously discussed are things that have already been discussed ahead of time, such as if we're decreasing one child's share, if we're having loans that need to be paid back to the trust after death occurs. Those are things that we want to make sure are discussed ahead of time. I always recommend that we do that in the form of a family meeting if we can. And I certainly understand most of my clients say, Dave, I don't want to have a family meeting where all my kids are together and I'm telling them, Bobby, I've cut you out, or Susie, your shares decreased because we paid for your first home or your college education, and Todd, you're getting the most of the estate because we love you the most. I get it. Most clients don't want to have those conversations in person. So if you don't want to have those conversations in person, the next best thing to do is to put a letter out that discusses all these things and what your goals are and what you're trying to do in regards to these family matters, so that it's written in writing from you. That letter's given to them after you pass away. They can read it. Hopefully they understand it. They appreciate it. And if not, we at least have evidence to take to court if the child decides to contest your estate plan. We have something that says, Your Honor, this is what our client wished. They put this in writing. It shows what their desires were. So probate, there's two types of probate you need to be familiar with that we're always trying to avoid. One is called living probate. The other is called death probate. Most of you are familiar with death probate. That's where when we die, we own assets. And because we own the assets when we die, we have to go through a court process called probate so that we can have our loved ones gain control of those assets. Probate in Arizona is triggered after a certain dollar amount. That dollar amount is $75,000 for personal property items, and that's cumulative. So that's adding up every single item that you have that's considered personal property. And if the total value of all those items exceeds $75,000, then we have a death probate problem after you've passed away, which means attorney's fees and court costs and time and delay and publicity and all the junk that goes with court. For real estate, that number is 100,000. So they break those two fees up into those two categories. Personal property is everything you have: checking, savings, stocks, bonds, mutual funds, your cars, and then real estate is the other threshold of 100,000. So if our assets exceed those $2 amounts, if we add everything up, then the only way to avoid that, the best way I should say to avoid that, is to have a trust in place that will take care of that issue. Living probate is where you're alive, but you lack capacity. So dementia, Alzheimer's, whatever, you can't manage your financial affairs anymore. So you're still alive, but you lack the capacity to manage your financial affairs. Now you have to go to court to get a conservatorship and a guardianship issued over you. Once again, that means attorney's fees and court costs and delay and all the junk that goes with that. Living probate can also be avoided by having a trust in place, having the trust own the assets, and then in addition to your trust, having healthcare documents in place where you've nominated somebody to make all of your healthcare decisions, so we don't have to get a guardianship issued over you in the event that you're incapacitated and cannot make your own healthcare decisions. So in Arizona, there's 4 healthcare documents we recommend everybody have. One is a living will, which is the physician's directive. It tells the doctors whether you do or do not wish to be kept on life support. That's the Terry Schiavo situation most of you are probably familiar with. The second one is a healthcare power of attorney, which nominates somebody to make healthcare decisions for if you cannot make your own medical decisions. Mental health care power of attorney, which authorizes an agent to commit you to a partial psychiatric hospitalization program. So if you had to be committed because you're running in the street at midnight causing harm to yourself and other people and you got to get back on your medications, then that's your mental health care power of attorney. And in Arizona, we actually do differentiate between healthcare and mental health care. So those are two different powers of attorney there. And then the final one is your HIPAA form. That's your Health Insurance Portability and Accountability Act authorization form, which just authorizes your loved ones, your kids, your spouse, whoever, to have access to your medical information so they can make decisions for you and know what's going on with your health care. Certainly your healthcare power of attorney would also typically be your HIPAA on your HIPAA form, so then they can access the information and make decisions regarding your healthcare. So those are the 4 healthcare documents that you should have in Arizona to stay out of guardianship issues. And then to avoid conservatorship, as long as you have a trust and the assets are owned by the trust, there would not be the need for a conservatorship if you became incapacitated. So death, probate, and living probate are things that everybody on this webinar can avoid. It's just a matter of having the proper documents in place, the legal documents in place, and then you don't have to worry about going through this process when incapacity or death occurs. Taxes. I'm not going to spend a lot of time on taxes. We have about 15 minutes left of the presentation, so I'm not going to bore you to death with taxes, but there are a couple that we need to go through. The first one is if you've moved here from another state that would be considered a separate property state, which most states in the United States are separate property states. There's only a handful of states in the United States that are considered community property states. Arizona is one of those handful of states that is a community property state. And basically what that means is in a community property state, we receive a very, very beneficial tax benefit. And it's called a step up or cost basis adjustment to the fair market value as of date of death for all capital assets. And so if I have a capital asset that I bought, let's say for $10,000, whatever, 20, 30 years ago, that's my cost basis in the property, $10,000. If I still own that property, that capital asset today in 2020, and it's worth, let's say 110,000. So it's appreciated $100,000 in 20 years. Then there's a gain in there. The difference between 10 and 110 is 100,000. So I have a $100,000 gain. And if I sell that asset, I owe a capital gains tax, 23 to 25%, federal and state. Well, if I don't sell the asset while I'm alive, but instead I hold on to the asset until I die, in a community property state like Arizona is, When death occurs, the cost basis will adjust to the fair market value as of the date of my passing, wiping out all the capital gain that was stuck in that asset. So if my wife or my kids want to turn around and sell that asset the day after I die or the month after I die, there's no longer a capital gains tax that has to be paid because all the gain has been wiped out. So very favorable, very beneficial. In a separate property state like Minnesota and Iowa and Illinois, almost every other state in the United States, that's a separate property state that's not community property, the cost basis adjustment when death occurs for a married couple is only half. So if I'm married, which I am, and I die first, and I have that $100,000 gain stuck in this capital asset, and I die first, then my wife's cost basis only adjusts by half. So it's only $50,000. Then I still have a $50,000 gain that's stuck in there. So if she sells it, it shows 23 to 25% on $50,000 gain. Whereas in a community property state like Arizona, the whole thing adjusts to the fair market values of date of death. So important to understand this, because if you have moved to Arizona from another state that's not a community property state, very beneficial to update your estate plan in this regard to take advantage of community property laws to wipe out capital gains taxes that there may be when death occurs. As far as estate taxes go, don't really need to worry about those too much anymore because the federal estate tax exemption amount has significantly increased. Today, our federal estate tax exemption amount, as I said, is 11.58 million. It's indexed for inflation. That's going to continue to go up until 2026. If Congress does nothing, then that will lapse back to what the law was prior to the Trump tax reform in 2017. And that will go back to $5 million indexed for inflation. So it's still a lot of money before we have a federal estate tax issue. And the good news in Arizona is we don't have a state estate tax. So not only is Arizona a good place to live, but it's also a good place to die. So no state estate tax in Arizona right now. Once again, laws can change. That may change. We are in an election year, and so if Biden is elected, he may change that, and they may drop the exemption amount. So it's just something you always have to keep your eye on to see where that federal estate tax exemption amount may end up. But those are some taxes just to kind of keep in the back of your mind and plan for to minimize those taxes if we need to. Digital assets, just going to cover this real quick. Some of you do have digital assets. Most of us do. These are online banking accounts that we may have. These are, email accounts, Facebook accounts, Twitter accounts, anything basically you do online. We want to make sure that you have usernames, passwords, and websites for all those. Those can be shut down, closed out after you pass away. So make sure you have a list of all those. You should have a list that says, my online banking account with whatever city is, this is the login, this is the username for that, this is what's in that account, and you're authorizing them, your trustee or your executor, to close those accounts down and to gain access to them after you passed away. So very important that you have a list of those digital assets. We nowadays do so many things online. We need to make sure we have a list of those things. Some other things to consider when we talk about estate planning: nursing home costs. How are you going to pay for nursing home costs? Those costs are only going to increase over time. So is there a plan? Do you have a plan in place? What is your plan? Are you privately funding your long-term care plan? Are you hoping that you're going to qualify for some type of government benefit called All-Tex in Arizona? Arizona's long-term care system. Medicaid is the federal government's form of that. Do you have long-term care insurance? If you do, how does it work? Have you reviewed that? Does it have inflation riders built into it? Is there a death benefit if you don't use all the long-term care insurance? If there is a death benefit, if you don't use the long-term care insurance portion or only part of it, who does that pay to? Who are the beneficiaries of that? Those are things you want to discuss. You want to make sure you have written out and your loved ones know about it and how it works. Remarriage of your spouse. These are often concerns for our younger clients. So they come in and say, well, Dave, what if I die and my wife, who's 50, 60 years old, decides to remarry Bob, and what happens to our assets that we worked so hard for? Can she just leave it all to Bob? We can plan to make sure that some of the assets are protected from those things. So those are things that you need to discuss ahead of time as part of your estate plan. Divorces. So if I die, my wife gets remarried to Bob, and that marriage doesn't work out. She gets divorced from Bob. Can I make sure that in the divorce, Bob doesn't end up with half of everything my wife and I worked so hard for? Yes, the trust can be drafted to make sure that we're protecting as much of the assets as possible from that kind of an event. How about our kids? Are we worried about our kids getting divorced from their spouses? I'm sure if we did a poll right now of how many of you on this webinar have a loved one that's been through a divorce, we'd probably get at least 50%, if not more, that would raise their hand saying, yes, I have a kid or I've got a grandchild that's been through a divorce, and it was nasty, it was ugly, it was terrible. And the last thing I ever want is my estate going to that slimeball in-law that's divorced my daughter. Your trust can be built to protect your kids from those things. Lawsuits, heaven forbid, you're dead. You've left the $1 million estate to your daughter, Susie. She's driving down the road. She hits a school bus filled with attorneys' kids on a day trip to the Supreme Court, and she gets sued. How can we protect your child's inheritance? Well, a trust can be drafted to protect that inheritance. So if she does get sued, it's protected. Or bankruptcy. What happens if 2008 comes back around and the economy tanks and we've seen unemployment shoot through the roof here with COVID-19, loss of jobs, bankruptcies increase? Can we make sure that the inheritance you're leaving behind would be protected in a bankruptcy like that? Yes, there's things we can do in the trust to protect the inheritance from future bankruptcies of your kids and your grandkids. And then, of course, taxes, which we've talked about and how we can minimize those, updating the estate plan for community property laws, making sure that if you do have an estate tax issue, we're planning for that to minimize the federal estate tax that you might have if your estate's large enough. Retirement plans, Secure Act. So last piece really on taxes, not gonna go into all the nuances of this. We have about 9 minutes left here and we'll finish this up and then open it up for some Q&As. But some of you may have heard that December 2019, there's this new law that's passed called the Secure Act. It stands for Setting Every Community Up for Retirement Enhancement. And basically what they did, there's some good and there's some bad with this. The good is if you're still working after 70 and a half, you can continue to contribute to your retirement account, which is it's a good thing, right? If I'm working at Walmart or whatever to get health insurance or whatever to help out with certain things, and I want to still contribute that check that I get to my retirement account, I can now do that under the Secure Act. Whereas before Secure, after 7 and a half, you could not contribute any more money to your retirement account. So Secure allows us to continue to contribute money to our retirement plans after we're 70 and a half, which is good. The second thing is if you did not turn 70 and a half prior to January 1st, 2020, you now can wait until you're 72 before you have to start taking your RMD. What is an RMD? It's your required minimum distribution you have to take every year. And if you don't take that RMD, then it's a 50% penalty for not taking it in addition to the tax. So it's a 50% penalty plus the income tax, which basically could wipe out your whole RMD. So that now has increased to the age of 72. If you were 70 and a half prior to January 1st, 2020, sorry, tough luck, you're under 70 and a half. You don't get to switch it to 72. You're going to remain under the old rule of 70 and a half and just keep taking your RMDs like you always have been. But for those that didn't turn 70 and a half before January 1st, 2020, you now got to wait till you're 72 before your RMDs start. The bad news is with the Secure Act is they basically got rid of the stretch distributions on your IRAs. And so prior to Secure, how retirement accounts worked and the great benefit of retirement accounts was I could have this $1 million retirement account that I've been putting money into income tax deferred, has been growing income tax deferred. I don't pay $1 of income tax until I start taking it out after I'm 72 now, 7 and a half before. And then I pay the income tax on it. And when I died, if I listed my granddaughter, who is, let's say, 15 years old, as the beneficiary of that $1 million retirement account, under the old law, she was able to stretch out that retirement account for another 60 years, letting it grow, continue to grow, income tax deferred, and just paying income tax on what she pulls out. which was great. It was awesome. It was a great estate planning vehicle, not just a great financial planning vehicle, but a great estate planning vehicle to pass on lots of money in a very tax efficient way. Well, you have to remember that when ERISA law was passed by President Ford, he never, and Congress never intended for us to be doing what we're doing with these retirement accounts, which is using them as estate planning vehicles, not as retirement planning vehicles. And so Congress finally got wise to that and said, all right, we're chopping out the ability for your loved ones to stretch out these retirement accounts for 60 more years after you've died. Now, under Secure, when I die, the maximum stretch out my loved ones will have is 10 years from the date of my death. So the entire retirement account has to be liquidated and taken out on the 10th anniversary after the year of the date of my death. There are 4 exceptions to that. Most people are not going to fall into these 4 exceptions, but there are 4 people that they call eligible designated beneficiaries, or EDBs. If you're one of these 4 EDBs, then you continue to get a stretch out or a modified stretch out. If you're a spouse, so if I die, I leave my $1 million IRA to my wife, she can continue to stretch it out over the remainder of her life expectancy. So if she has a 20, 30-year life expectancy, she'll be able to continue to defer the income taxes for 20 or 30 years because she is an eligible designated beneficiary under the Secure Act. So that's one category of people that still get a stretch. The second is a minor child of mine, the owner of the IRA. So it cannot be a grandchild. It cannot be anybody other than a child. It has to be a minor. What's minor? Under Arizona law, it's 18 years or younger. So if I have a child that's 21, not going to fit in that category. They have to be 18 years or younger and that to be a child of mine. Then they get a modified stretch. Basically, they get to stretch it until they turn 18, and then they get 10 years starting from 18 until the 10 years has gone by, so 28. And then at 28 years old, the entire IRA has to be distributed out, all the income taxes due. So that's your second category. It's not really a stretch, it's kind of a modified stretch they get. Next is disabled or chronically ill. So if I have a disabled or chronically ill beneficiary, say I have a child with special needs, receiving disability benefits from the state, can't work, can't hold down a job because of the disability. If I leave my IRA to them, they do get a stretch out for the remainder of their life expectancy. So if I have a daughter who's on disability benefits from the state of Arizona, and she is 20 years old, and I die and leave the IRA to her, she will be able to stretch it for the remainder of her life expectancy, another, 60 years. So that's the third category of an eligible designated beneficiary that still gets a stretch. And the final one is a person that's less than 10 years younger than me, the owner. So if I left it to my sister, who's 5 years younger than me, then she gets to stretch it over the remainder of her life expectancy. So I'm 45, let's say she's 43. I die today, leave the IRA to her. She's going to have another 15, 20 years to stretch out the IRA, taking gradual distributions over time, not having to take it all in 10 years. So that's basically the good and bad of the Secure Act. The best, bar none, asset to leave to charity, if you're philanthropically minded, is a retirement account. Every dollar you leave to Sun Health Foundation or your favorite charity goes to them income tax free. There's no tax that's paid. So they'll get the dollar, they'll liquidate the IRA, and they'll use the full dollar to benefit the foundation. Whereas if I leave the IRA to my daughter, she doesn't get a dollar. She pulls a dollar out, she gets 70 cents, 30 cents goes to Uncle Sam. So we're losing money there. So once again, if you're philanthropically minded, you want to leave a charitable bequest when you pass away, the best asset to do that with is going to be your retirement account. You still can do qualified charitable distributions from your retirement accounts. That hasn't changed with the Secure Act. So if you're taking your RMD every year and you're distributing it to Sun Health Foundation or another one of your favorite charitable organizations, you can continue to do that under the Secure Act. That hasn't changed. One of the things to quickly go over is under the CARES Act that was passed this year because of COVID-19. If you have not already taken your required minimum distribution, you do not have to take your required minimum distribution for 2020. And a lot of people say, well, then I have to take 2 required distributions in 2021. No, you don't. It's just 2020 just goes away. There's no required minimum distribution for 2020. Next year it just picks up and you keep on doing what you've always done. So it's not like you have to take 2 next year. So keep that in mind. But if you need the RMD to live off of, you're gonna take the RMD anyway. And even if you don't have to take the RMD because of the CARES Act, but you still want to do a qualified charitable distribution, you can still do that. So just because you don't have to take the RMD doesn't mean you don't have to do your qualified charitable distribution this year. If you want to make a qualified charitable distribution this year, you can certainly still do that. Pull money out of your retirement account and send that off to Sun Health Foundation or your favorite charity. So just some things to keep in mind there with Secure. So last question here before we get to my last question from me before we go through your questions is, how do you want to be remembered? What's the legacy you want to leave behind? Is it a mess? Are the final chapters of your life going to be written with frustration and chaos and heartache and pain and money going out the door to attorney's fees and court costs and all that? Or are the final chapters of your life going to be written with love and with fond memories and how easy you made things for those that you've left behind? There are steps that we can all take today to make sure that those last few chapters of our life are pleasant chapters and pleasant memories that remind others of who we were and the legacy that we wanted to leave behind. And that's up to you and the steps that you're going to take today to ensure that that does happen. So with that said, we're going to open it up for questions. Darren, are there some questions that we have?
Dave, we do have some questions that have come through. Thank you for the presentation and all that information. Just as a reminder to those who are attending, if you do have some questions that you haven't already written, please feel free to do so in the Q&A tool at the bottom of your screen. Dave, the first question comes from Pat. How do I provide for my child who has developed issues and is not able to take care of herself without having her inheritance going to the state? I would like her inheritance taken care of by a sibling and given to her when she needs extra things. She lives on Social Security. Is this possible?
Absolutely, great question. And yes, it is possible to do that. Just real quick, Darren, you can see my slide, right?
Yes.
Okay, I see that little window at the top again that says, please move this away from your screen. So I'm hoping that things are still working. But that's a great question and one that I kind of addressed as I went through the presentation. Absolutely, you can make sure that your special needs child, grandchild is taken care of after you pass away, making sure that their disability benefits are not taken away or ruined in any way. And the way you do that is through the creation of a trust and making sure that when you pass away, the assets are left in what's called a special needs trust for your loved one. And then we can appoint your other daughter or a friend or a niece or a nephew, whoever you want, to manage those monies for that special needs child. That is the best way to do that. You certainly do not want to leave assets directly to the special needs child or grandchild. It'll screw up their disability benefits, and that's the last thing that you want.
Okay, thanks, Dave. Next question from Pat. How do I make sure things such as dish sets, silverware, jewelry, family Christmas ornaments, etc., go to the person I want to have them? Seems like these are not things to go in a will.
Yeah, great question. So this is one where we want to make sure we have a personal property distribution list that we talked about on the 8 things that we should all be doing. Basically, it's just a list that you make up that says, I want my personal property items to go here. So you describe the item and then you list who's going to get it. I've actually seen some clients that'll go through and they'll take pictures of the item. They'll take a picture of the grandfather clock and then they'll print out the picture and they'll write the name of the kid or the loved one that's supposed to receive it underneath the picture. So there's lots of ways to do it, but you want to make sure you have a list and be as detailed as you possibly can in that list and who's going to get what.
Okay, Dave, staying on the topic of the list, this one comes from Jamie. Can one only list specific personal properties versus everything on that list?
Good question. Yes, the personal property list under Arizona law can only be comprised of personal property items. So we cannot list bank accounts, we cannot list titled assets. So I can't say, I want my Chase checking account that's got $50,000 in it to go to my son, Bob. You cannot use the list to do that. You can only do personal property items, stuff that doesn't have a title to it, my couch, my TV, my jewelry, my artwork, my furniture, that stuff.
Great, thank you. All right, next question. This is from an anonymous attendee. If assets have beneficiaries, won't we avoid probate?
Good question. So yeah, if we have beneficiary designations on our assets, then there will not be a probate. And I always think of it this way: it's good, better, best as far as ways to plan. You certainly can list beneficiary designations on all of your bank accounts. And then when you die, as long as those beneficiaries are still alive, as long as those beneficiaries are not special needs, then there will be no probate. Those assets will go directly to those beneficiaries. The downside to doing it that way, so there's always pros and cons. The downside of planning your estate that way is it does not take into account incapacity issues. So if I become incapacitated before I die, and all I have done is list beneficiary designations on my accounts, and my son, Johnny, who I listed as the beneficiary of my checking account, needs to gain control of that checking account while I'm incapacitated, pay bills and do whatever while I'm incapacitated, the beneficiary designation form is not going to do anything for him. They're not going to give him control of the account because I'm still alive. So it won't solve incapacity issues, number one. And the second thing is once again, falling under the assumption that we all worked extremely, extremely hard for these nest eggs that we have. And all of our nest eggs are different sizes, 500,000, 5 million, 50 million, whatever it is. You worked extremely hard for that money. And by doing simply a beneficiary designation, you're not protecting those assets after you're gone. So yes, I could list my daughter as the beneficiary of $1 million brokerage account at Charles Schwab. I die, she takes in a death certificate, they give her the $1 million brokerage account, no probate. And let's assume I didn't become incapacitated before I died. So she's got $1 million brokerage account now, but she gets sued. What happens? It's gone. She goes through bankruptcy. It's gone. She gets divorced. It's part of her divorce. It's gone. So once again, yes, you can do it to avoid probate. Much better way through a trust. It would protect the assets and make sure not only it protects from incapacity, death, but also protects the assets for your children.
Great. Next question is, can you provide an example of tax filings?
Yeah, so there's certain tax filings that you have to make sure that you're going to take care of after death occurs. So in the year of death, you're going to file a 1040 and a 1041. So you're going to file a 1040, which is your personal return. It's your final personal return. That's from January to the day of death. That's your personal return. And then you're going to file a 1041, which is an estate return from the date of death until the end of the year. So those are your income tax returns. And then if we have to file a federal estate tax return, because let's say your estate's worth, you're single and your estate's worth $13-14 million, then we'd have to file a federal estate tax return. That's a 706 that we would do that on. Or if we're just trying to elect portability so that we can port the deceased spouse's unused exemption amount over to the surviving spouse, we still want to file the 706 within a timely manner to make sure that we get that portability. So those are some of the tax filings that we need to make sure take place.
Okay, next question. With regard to IRAs, it needs to get the name changed to a person who is the beneficiary. How does it get connected to the trust when now in their name?
Good question. So with retirement accounts, there's a couple ways you can plan with those. If your estate plan has been updated, it's got language in it that will make the trust a qualified trust, or a see-through trust is another term they use, which just means it has to have some technical language in it to make sure it doesn't blow up the IRA and cause the IRA to all be subject to income tax all at once. If it is drafted properly, then you can make the trust a beneficiary of the retirement account. And then when you pass away, the trustee of the trust is going to send a death certificate to Vanguard, Charles Schwab, or whoever. The trust will actually become the inheritor of the IRA. And so the trust inherits the IRA. And then based on whatever the trust says divide the IRA out to 4 different beneficiaries. Then we get the financial institution to carve that IRA out into 4 separate inherited IRAs to the beneficiaries of the trust. With our trust, what we do is we keep the assets in trust. The rule against perpetuities in the law of Arizona is 500 years. That means we can keep assets in trust for 500 years. That's a long time. So what we like to do with our trust is keep the inheritance in trust as long as we possibly can. That provides the divorce protection, lawsuit protection, bankruptcy protection for our children, our grandchildren, or whoever we're leaving the assets to. In this case, the IRA would then float down into inherited IRAs in these sub-trusts. So these sub-trusts actually become the inheritors of the IRAs instead of my child directly.
Okay, Dave, we've got a handful of questions left. Next one is there a comprehensive book or books you would recommend that summarizes the information you provided in the webinar to do further study?
Oh, we have some books that we can certainly send to you. We have a seminar booklet that we can send to you that summarizes a lot of this information. It makes it easy to understand and to follow. Almost any basic estate planning book out there that you find would summarize a lot of this information for you. But like I said, we've got 3 or 4 books we can send you. If you send us your email, we can send you a couple of the books and a seminar booklet that we have.
Okay, next question is from Diane. Does the successor trustee have a timeline to notify all beneficiaries of the trust terms and who gets what?
Good question, Diane. Yes, under Arizona law, we do have to notify the beneficiaries of a couple of things. Number one is we have to notify the beneficiaries that you or whoever is serving as the trustee has decided to serve. We have to send them the contact information for the trustee, how to get in touch with the trustee, name, address, contact information. And they're entitled to a copy of the trust. And under Arizona law, you can send them a redacted copy of the trust. We typically just send the beneficiaries the entire copy of the trust, because typically if you send a redacted copy of the trust document, then the beneficiaries start to wonder, what are you not telling me? What are you hiding from me? We certainly don't want to open up that can of worms. And so we're not hiding anything. Send them an entire copy of the trust, so they have that to review and to look at and ask questions. And we want all that to be sent to them within 60 days.
Okay. Next question is from Carl, and I think I understand his question. I just want to make sure. It says, pour over will in trust for things not listed.
Yeah, so basically, what is a pour over will? What's the job of the pour over will? Your pour over will is a safety net. Its basic job is to make sure that if you screwed up and you left assets outside your trust for some reason, which once again is the #1 reason why trusts fail. People just forget to continue to put assets in the trust like they should. And so if that happens, let's say I created my trust 30 years ago, time went by, I acquired new bank accounts and whatnot, I just forgot to put them in the name of my trust and I die. Well, in order for my loved ones to gain control of those assets that were not in my trust, they have to take my pour over will to court, open probate, then the probate court will appoint my nominated executor inside my will to gain control of those assets. Once they've gained control of the assets, they'll pour the assets into the trust and then the trust will distribute them out. So the pour over will works in conjunction with the trust. Our goal is that we're never using a pour over will, because if we are, it means you've screwed up, you left assets outside the trust, which if you're coming every 3 years to review stuff, we're pretty good about making sure everything is in the trust and it's up to date.
All right, thank you. Dave, we got 3 more questions. You have time for all 3?
Let's see, 11:42. Yeah, we can do a few more.
All right, perfect. Next question comes from Ann. How about a private fiduciary for those of us that don't have anyone to be our trustee or executor?
I get this question a lot. Yes, we never make a recommendation of one private fiduciary. We'll give you 2 or 3 recommendations, and then we always tell you to go interview them, research them, make sure you feel comfortable with them. But we have a list of private fiduciaries that we refer people to. So we'll give you that list, and then you'll go and do your research and find out who you feel comfortable with, and pick the person you feel most comfortable with.
All right, perfect. Next question is from Diane. Which creditors' bills, for example, a hospital, must a personal representative or trustee pay? And are they personally responsible for failing to pay them? How would a creditor know the name of a trustee to follow up with?
Good question. Good question. So when death occurs, once again, you're going to have an inventory of all the assets and an inventory of all the debts and the liabilities and obligations that are out there. And there's 2 types of creditors. We have known creditors and we have unknown creditors. So for a known creditor, that's somebody that we know exists, right? So if let's say my wife was admitted to Mayo Clinic before she died, and I knew that I was going to have some hospital bills to pay. That's a known creditor. They've sent me a bill. I know I owe them money. That's a known creditor. And then we have unknown creditors, people that we may not know exist. Let's say my father died. He lives in Grants Pass, Oregon. I don't really know anything about his estate. I don't know who he owes money to. That would be an unknown creditor that he may owe money to. So there's two types of creditors, known and unknown. For known creditors under Arizona law, we have to notify them. So we notify them, we send them a letter saying, we know that you're a creditor of the estate. Mr. Smith died, he owes $10,000. And then you let them know the amount of time that that creditor has to file a complaint against the estate to be paid. And that is based on the publication that you do in a local newspaper. So what we do is we file a publication in a local newspaper, and that runs for 3 consecutive weeks. From the date of the first publication, they have 4 months from that date to file a claim against the estate to be paid. So the unknown creditors are taken care of through the publication in the local newspaper, people we don't know we owe money to. The known creditors are notified by letter, and then they have 4 months from the date of the first publication to notify the trustee that they're making a claim against the estate. And then you wait the 4 months, you see who's made a claim. If whoever's made the claim, you reach back out to them, you try to settle the debt if you possibly can, and take care of that. Personally responsible for those obligations? No, you are not personally responsible for the debts and obligations of the deceased person. You are obligated as the trustee or executor to notify them and let the creditors know that they can file a claim and the time frame in which they have to file the claim, but you're never personally liable for those debts.
All right. Next is from Sharon. As a single female with no children and a small family, what is the most important thing I can do to set my beneficiaries up for success?
Ooh, it sounds like a simple question, but there's a million things that go in my head when somebody asks something like that, because there's so many things that can go into that. Who are the beneficiaries? You know, if you're charitably inclined and there's no kids, there's no grandkids, you're single, you just want to leave it all to charity, then there's a different way I would recommend that you plan your affairs. Certainly with your retirement accounts, list the charities directly on the retirement accounts. That way when you die, the retirement accounts go directly to your favorite charity and no taxes have to be paid on those. But if there's real estate and whatnot, if you own a home, you want to have a trust in place to take care of the real estate, to pass that on down, and then whoever you pick as the executor trustee of your trust is going to sell the asset and distribute the proceeds according to the terms of your trust. So I would have to know more. Who are the beneficiaries that you're trying to leave everything to? Is there real estate involved? Is there not? Those are things I'd want to know. Certainly come in, sit down. I can walk you through it. It's an hour and a half of my time. Don't charge for that. We can talk about it.
All right, Dave, one more question. Are A and B trusts still in vogue?
It's a good question. It depends. There's lots of stuff that you'd want to take into account when you think of whether you need an A/B trust. Some things to consider. If this is my second or third marriage, and I have kids from a previous marriage, and I want to try to protect my half of the estate or my share of the estate for my children after my spouse dies, then an A/B trust is still going to be beneficial. If I have a taxable estate, an A/B trust is still going to be beneficial. If I'm worried that my spouse might get remarried after I die, if I'm young and I'm worried that my wife might get remarried after I die, an A/B trust is still beneficial. So it depends on, what I'd say is the size of your estate, the nature of your assets, how old are you, and what you're trying to do with your estate. Is this a second or third marriage? Once we are able to go through those things and answer those questions, then I could say, you don't need an A/B trust anymore. Yeah, it still makes sense, and there's some good benefits to an A/B trust still.
Okay, Dave, that was all the questions that were in the Q&A box. If you didn't have a chance to submit a question, or if we didn't get to your question, we apologize. We are getting a little bit low on time, but Dave, I'm going to turn the time back over to you.
Perfect. Thank you, Darren. And I'm going to switch through my slides here, Darren. If it doesn't pop up, just let me know, because I still see this. Please move the this away from the screen. So this is what was popping up last time when you weren't seeing the slides. But I'd just like to say thanks for the opportunity to present today. I'd like to thank Sun Health Foundation for this opportunity to present. Hopefully this was useful to everybody and you were able to gain some information, some insight. Once again, the last thing we'd ask everybody to do is please fill out the evaluation form. Once again, it helps us out tremendously. And certainly there's probably lots of questions we didn't get to. So by filling out the evaluation form, you can come in and sit down with me for an hour and a half of my time. We can go through the questions, discuss those, and what it is you're trying to achieve with your estate plan and help you out with that, in addition to being able to meet with Sun Health Foundation and talk about your charitable gift planning ideas and opportunities that are out there to satisfy those bequests. So please fill out the evaluation form at the end. In conclusion, we're going to have Pastor Lowell Nelson give his final remarks, and then the webinar will end. Once again, thank you everybody, stay safe, and hopefully we'll see you soon.
Hello everyone, special thanks to Dave for sharing his expertise and to all of you who joined us. The legacy you leave can also be one of generosity for your community in support of superior health care and wellness. From the transformation of emergency services to cancer fighting treatment to spine health, orthopedics, women and infant services and more, Sun Health Foundation's $48 million Generosity for Generations campaign offers the opportunity to support the causes that matter most to you. Make a lasting impact for future generations. We invite you to learn more. Please call us at 623-471-8500, 623-471-8500, or visit sunhealthfoundation.org. I'd like to point out that those of you participating today online will receive a follow-up email that includes the link to a brief survey. We hope you would take a moment to share your thoughts. Your feedback is important to us. In closing, I want to emphasize your community health and wellness resources continue to be here for you. We're hearing that many people are delaying seeking medical care because of the COVID-19 concerns. It's so important to know that Banner Boswell and Banner Delhi Webb hospitals are taking all the steps they can to protect you and your loved ones. So please don't delay. Your health and well-being are so important to us. And because of the pandemic impacts us in so many different ways, I'd just like to close with encouragement to testify. And what I mean by that is sharing your statement of faith, encouraging organizations and loved ones you're entrusting with your financial resources to continue the quest for healthy living and healthy communities. Don't just make it a financial document, make it your statement of faith as a steward of life. You are generous because you sense a call in which to empower organizations like Sun Health to generate vital ministry for years to come. So take positive action and share your encouragement for the agencies and the next generation of people, both in your written documents and to them in your conversations, for those people who will continue your legacy. Your words and actions make a difference. So thank you for joining us here today. Take care, stay safe, and be well.